Welcome back to The Explainer. Today, we're going to break down the single most critical and honestly the most often missed step in estate planning, how to actually make your trust do its job.
So, you went through all the effort of creating a living trust, you signed the papers, and you think you're all set, right? Well, a lot of people miss the one crucial action that comes after all that, and it leaves their entire plan completely vulnerable.
And this right here is the heart of the issue. If you don't legally move your assets into the trust, it's literally just an empty box. It's a stack of paper that owns nothing, protects nothing, and gives you absolutely none of the benefits you thought you were getting.
Okay, so before we dive into specific assets like houses and bank accounts, there's one foundational concept, a golden rule, if you will, that you've got to understand. It applies to everything. So what does funding actually mean? Well, it's really just the official term for transferring ownership. You're taking an asset that's in your name, personally, and retitling it so the trust officially owns it. But the key, the real secret sauce, is in how you write that new title. And here is that critical distinction. You can't just transfer an asset to the Green Frog Trust. A trust itself can't technically hold a title. You have to transfer it to the trustee, the person in charge, who then holds that asset for the trust. Getting this wording right is what makes the whole thing legally legit.
All right, let's start with the big one for most people, real estate. Whether it's your home or a rental property, the process for this is very specific.
The legal tool for this job is called a warranty deed. Now, you might hear about using something called a quitclaim deed, but be careful, that can actually jeopardize your title insurance. A warranty deed is the clean, correct, and safe way to transfer your real estate.
The process is actually pretty simple. You are the grantor. That's the person giving the property. And the grantee, well, that's you again, but this time you're wearing your trustee hat. You're basically signing the property over from yourself as an individual to yourself as the manager of the trust. Then you record it with the county and boom, it's official.
Now, what about business interests, like an LLC or a corporation? It is so important to get these into your trust if you want to keep them out of probate court.
For a business, you don't use a deed. You use a much simpler document called an assignment of interest. It's exactly what it sounds like. You're just formally assigning your ownership from yourself over to your trust.
And here's a fantastic pro tip. You don't actually have to go amend your LLC's operating agreement to show the trust as the new owner. By leaving your personal name on it, you can avoid a lot of scrutiny from banks. Otherwise, they might ask to read your entire private trust document just to give you a loan. It's a really smart way to maintain your privacy.
But, and this is a big but, before you do anything, you have to check your company's own rulebook. Your operating agreement might have a permitted transfer clause, or you might need to get approval from your partners. If you don't follow the internal rules, that transfer could be challenged and invalidated down the road.
Okay, let's pivot to your liquid assets. You know, things like your bank accounts, brokerage accounts, CDs. These require a totally different approach than real estate or a business.
And I really can't stress this enough. You cannot simply write up a document assigning your bank account to your trust. It won't work. Financial institutions just don't recognize those kinds of documents. It will have zero legal effect.
The only way to do this is to go to your bank or brokerage and open a brand new account titled correctly in the name of the trust. Then, you have them transfer all the funds and stocks from your old account into that new one. And make sure you check your statements. If they don't name the trust, it's not funded correctly.
So what about everything else? You know, all the stuff that doesn't have a formal title or an account statement. We're talking jewelry, art, furniture, that collection of tools in your garage. How in the world do you get that stuff into the trust? For all those untitled items, you use a simple but really powerful tool, a personal property memorandum. It's basically a single document you sign that transfers all of your personal belongings into your trust all at once.
And this really shows you the modern, efficient approach. The old way involved creating something called a Schedule A, where you literally had to list every single thing you owned. Can you imagine how tedious that would be? The personal property memo gets the exact same job done with just one signature. It's so much better.
Okay, now for a pro tip that can make this entire process dramatically easier, especially if you happen to own multiple assets. Here's the strategy. Think of an LLC as a big container. You hold your properties or your investments inside that LLC. Then, instead of moving each asset into the trust one by one, you just perform one simple action. You assign your ownership of the entire LLC into the trust.
The difference in effort is just stark. I mean, instead of juggling multiple deeds and opening new bank accounts, you just sign one document. By moving the container, the LLC, you move everything inside it all at once. It's a total game changer for efficiency.
Okay, that was a lot of ground to cover.
So let's do a quick recap and boil it all down to the essential action you need for each of the 4 main asset types we talked about.
Here it is, all in one place, your cheat sheet. For real estate, you need to sign and record a warranty deed. For business interests, you execute an assignment of interest. For financial accounts, you've got to open a new account in the trust's name. And for all your personal belongings, you sign a personal property memorandum. 4 asset types, 4 distinct methods.
By taking these steps, you move way beyond just having a plan on paper. You've successfully filled that empty box, turning it into the powerful tool you always intended it to be, one that can actually protect your assets and preserve your legacy.